ambiguous, right? And then you have Sonia Sotomayor and Elena Kagan and Ruth Bader Ginsburg, who wrote passionate defenses about how we must always give priority to the biological parents of a child, because in this case they were supporting the Native American community, and then the very next day they signed for same-sex marriage, which basically would do the exact opposite. You guys see what I'm saying? It's a huge hot mess, right? This is a very, very complicated situation. Let me read a little bit about this case so you can understand how this goes, all right? The lineup of justices concurring and dissenting was topsy-turvy. In U.S. versus Windsor, at stake was the definition of LGBT families as perfectly equal, regardless of the biological reality that they can never acquire children without taking them from someone else. In adoptive couple versus baby girl, at stake were a father and mother who made love and created a baby but were less stable than two biologically unrelated people in another state who had money and really wanted to raise the girl. Adoptive couple was decided one day before the Windsor decision was published. Without the court's strong indictment of biological parenthood and disregard for the history of cultural genocide in the adoptive couple case, it is arguable that Justice Kennedy would not have had enough ammunition to decide Windsor in the sweeping way he did. In both cases, what lost was the link between the child and its mother and father. You guys follow what I'm saying? Because the majority voted against the Indian father in the Indian Child Welfare Act case, and then the majority of the court voted in favor of same-sex marriage the next day. Justice Scalia was consistent in affirming the role of biological kinship by dissenting from Alito's decision in adoptive couple and dissenting from Kennedy's decision in the Windsor case. Now, however one tries to make sense of this dizzying pair of decisions, the result is strong in one direction. The Indian Child Welfare Act of 1978 and the Defense of Marriage Act of 1996 were weakened so severely that one might say that they were disabled by the court. Justice Alito's majority opinion in the adoptive couple case opens with extensive quotes to explain what the Indian Child Welfare Act was about. So he gives a very long, I won't read the whole thing, disquisition at the beginning of what the purpose was, and he basically said this. He overrode the three considerations. The first is that any party seeking an involuntary termination of parental rights to an Indian child under state law must demonstrate that active efforts have been made to provide remedial services and rehabilitation programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. Second, a state court may not involuntarily terminate parental rights to an Indian child in the absence of a determination supported by evidence beyond a reasonable doubt, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian was likely to result in serious emotional or physical damage to the child. And third, with respect to adoptive placements for the Indian child under state law, a preference shall be given in the absence of good cause to the contrary to a placement with first a member of the child's extended family or other Indian families. He overrode these decisions. And what he did to override those three considerations was he quoted a lot of the text messages that went back and forth between Dustin Brown, who was the Indian father, and the mother. And so he emphasized quite a bit things like this. He refused to provide any financial support until the two had married, because he was trying to get the mother to marry him, and he basically said, I want you to marry me, or else I won't support the child. And so that was one of the things that was used against him, implying that he was making it very difficult for her to be able to support the child. In June, they sent a text message asking if he would rather pay child support or relinquish his parental rights, and he responded via text message that he relinquished his rights. Now, why did Brown not have custody at that point? Why did he relinquish his rights? Why did he not support the baby girl during the pregnancy and just afterwards? The answer to these questions, I would argue, is not that he was a bad parent, and certainly not that he should have never been the father of the girl in the first place. Like the vast majority of children in the world, Veronica was born into an imperfect situation and had imperfect parents. Imperfections are common in communities that have had high poverty rates. Dustin Brown was a soldier in the U.S. Army, and he wanted to marry the woman who he had impregnated. He was trying to compel her to marry him, and all of that text messaging was then used against him. Now, what's interesting is that the family that ended up taking custody, and they now have custody of baby Veronica, was a white couple, and the father is a very wealthy contractor with a defense firm. So there's an added irony where the guy who's actually there in Afghanistan and has been taken by the US military and removed from his family loses the custody of his daughter to someone who gets to work on the home front. And so there's a lot that we have to think about with this case and the precedent it sets about whether we're going to be a forgiving nation, whether we're going to be respectful of people's circumstances. Are you going to be a harsh nation that basically takes children away from people because they're poor? And if you open the door to that, there are a lot of questions as to how far that could go. Regardless of these tangential issues, the fact remains that the United States Congress did pass a law in 1978 to protect American Indians from cultural genocide. The tininess of the fraction of Veronica's Indian bloodline did not negate the pretext for the law. The only way to stop them from being erased entirely is to keep the few who have survived within the orbit of their origins. So that was the second point that I think is important for us to look at, is the impact of Obergefell far beyond the gay community on where is it leading us as a country in terms of how we respond to the real life situations that often produce children. Very often people have children and can't raise them when they're first born. There's an entire foster care system that is based on trying to address that. And the decision in the Indian Child Welfare Act almost seemed to sweep all of that, the logic behind the foster care system, aside. Okay? Now the last chapter is that I'm going to talk about, and then I'll just open it up for questions, is about the problematic use of civil rights history, and particularly the 14th Amendment, to argue for LGBT rights. And specifically, this is because the 13th and 14th Amendments to the Constitution go together. Let me read you a little quote from a constitutional scholar who spoke about this at a conference at Columbia, about why it is that the 14th Amendment was passed so soon after the 13th. Time quickly revealed that the constitutional ban on slavery did not adequately protect the fundamental rights of newly freed slaves. The black codes in the South demonstrated that notwithstanding the formal recognition by those states of the abolition of slavery, the condition of the slave race would, without further protection of the federal government, be almost as bad as it would be before. The 14th Amendment was designed to remedy those identified weaknesses in the rights protected by the 13th Amendment. The 13th Amendment was written it's very vague. It's actually quite a problematic amendment. It says slavery, neither slavery nor involuntary servitude shall exist within the United States or its territories, and the second clause says Congress shall have the power to enact things in its rights. Now the problem is, what is slavery? And how do we figure out what that means? I would like to put forward that there are texts you could look at that clearly demonstrate what the abolitionist movement presented as the problems of slavery. Samuel Sewall wrote a text called The Selling of Joseph in 1700, which was based on the selling of Joseph by his own brothers to his cousins, the Ishmaelites, in the book of Genesis. And he said, this exemplifies slavery, this is what is wrong. And it's the selling of human beings. And in particular, he highlighted three separations. The separation of husbands from wives, the separation of children from their parents, and the separation of man from nation, of people from where they came from. And those were the three principal problems of slavery. Very hard labor is something that exists in places where there is not slavery. Violence exists in places where there is not slavery. Racism exists in places that there is not slavery. I'm not comparing gestational surrogacy to being forced to labor on a sugarcane plantation. But there is a basic foundational problem here, because as we get deeper and deeper into this, and as Obergefell, the ripple effects are starting to be felt. Gestational surrogacy is being pushed in New York State. It's being pushed in Louisiana. It's being pushed all over the world. There is some pushback now from Mexico and from the European Union. The problem is, how close do we have to get to the buying and selling of children for us to worry about the triggering of the 13th Amendment? Or have we basically abandoned any concern about the exchange of money for the custody of a human being? Is there something fundamentally more dehumanizing about buying someone than there is about giving a home to someone who is in need? And that's another major question. And I think that these three fronts that I just pointed out to you are very complicated questions. They're things that are going to require a lot of scholarship, a lot of reflection. And I think we're going to have to fight for those, because I think that there is a fundamental right of a child to its mother and father that's being undermined piece by piece. And we have a golden opportunity in a sense, because the question about whether homosexual relationships are moral is out of our hands. You know, and so you can focus now on the collateral questions of what Obergefell is going to do to children's rights. So I'll just end there, and then if you have any questions. Yes.
Well, thank you, Bonnie, for a very interesting, powerful talk. And I wonder if you could say more about a point you made early in your remarks, which point I found very striking and I think, as you suggested, counterintuitive, namely that the well-being of children in same-sex households was adversely impacted when the parents, so to speak, married. Which now that you mentioned it, you know, as you explained, is well, now that stranger, or let's say relatively speaking, the stranger, the non-biological caregiver now has a kind of dominion over the child, and that can be stressful. That does make sense, but I wonder if we have reason to believe that that condition or development is somehow worse for children when there's a same-sex step-parent, as opposed to the obviously very common phenomenon of children being raised by step-parents, one mom and one dad.
I think it is worse. That's my sense from the testimonials that I've recorded from people for a number of reasons. Very often, when you're talking about having two gay adults in the home and one of them has a child, one of them doesn't, there is a kind of over-eagerness very often for the one who is not the biological parent of the child, because they've dreamt of having a kid for so long and this is their only way to have it. And so there's a sense of a kind of triangular manipulation of the child that is maybe not ill-intended. It's not a malice on the part of the person, but the child very often feels imposed upon, like they're being stalked. Do you know what I mean? Like it's something that's kind of an unwelcome presence in their life. There's also more political controversy, because very often when you have two people from the gay community who are raising children, there's a question, are they going to take the kid to gay pride parades? Are they going to go to the elementary school and tell everyone at the whole school, we're lesbian moms or we're gay dads? And that's a story, that comes up a lot in the testimonials of children. They didn't like that. Overwhelmingly, they didn't like that. Often, when I would have debates with people who were representing the gay community, they often wanted to make each of these individual cases an issue of people having problems with their peculiar parents, but not the problem with the gay community, when in fact, overwhelmingly, it's the opposite. Usually the children raised in same-sex couples' homes, they love their individual parents, but they had problems with the bigger